Chief Justice and the Associate Justice of the Supreme Court of the United States. Oyez, oyez, oyez. All those who have business before this, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. You may be seated.
Good evening. And welcome to this session of the court. We are now calling the case of Danoff versus State of Olympus. Are the petitioners ready to proceed?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. Madam Chief Justice, and may it please the court, my name is Thomas Sue, and I represent petitioner Billie Jean Danoff on the issue of standing and on the merits of her First Amendment claim. My co-counsel, Meridian Paulton, represents petitioner on the merits of her equal protection claim. A law properly drawn to stop voter fraud will do two things. First, it will suppress fraudulent votes. And second, it will allow every lawful voter to cast a ballot. Because the Voter Identification Act fails on both counts, we ask the court to reverse the 14th Circuit's decision and rule the act unconstitutional. And to that end, I offer two arguments. First, petitioner meets the three-part test set forth by this court in Lujan versus Defenders of Wildlife, so she has standing to bring this suit. And second, petitioner's First Amendment rights are impermissibly burdened by the act, without the act advancing any legitimate state interest, so it fails even the basic test of rationality.
Let me ask you this about the first prong of the standing
Certainly, Your Honor.
criteria. The plaintiff must have an injury in fact. What is the injury in fact here?
Well, Your Honor, the injury in fact ultimately stems from the fact that my client was unable to cast a ballot in the July 7th primary. In addition, she's also suffered an injury in fact from the fact that there was a barrier placed between her and the ballot box of any kind. The main locus of the dispute today, however, doesn't appear to be on the injury in fact prong. It instead appears to be on the causality prong, as the state has alleged consistently that my client is essentially the author of her own circumstances.
Why should we ignore this injury in fact? Isn't that why you say it's not an important prong? I mean, I think the idea that we have to identify an actual injury, or else the court has no jurisdiction.
Well, certainly the court does, Your Honor. However, that doesn't appear to be the main locus of the dispute, although it obviously is disputed to a certain extent by the parties to this proceeding.
So what relief would your client be seeking?
Well, Your Honor, it would be declaratory and an injunctive relief, although the redressability prong of the Lujan test has been stipulated to by both parties. As such, the only two prongs before the court today are the injury in fact prong and the causality prong.
But to go back to the question is, if we agree with you on your client's position, what is the remedy?
Well, Your Honor, the remedy would be to declare the act unconstitutional as it's applied to my client and to others who are similarly situated, who find themselves in fundamentally the same situation that my client finds herself in.
But you are not asking this court to do anything about the actual election, correct?
No, Your Honor, we don't plead any sort of violation of that. And we don't ask the court to, in any way, reverse the decision of the people of the state of Olympus. That's certainly not what we're asking the court to do today.
Well, how would you actually phrase the remedy? If you say similarly situated, are you talking about anybody who didn't vote because they couldn't get a voter ID, no matter what reason?
Certainly.
Or would it be something much more attuned to only the specific facts to this particular individual?
The second, Your Honor, something very specifically attuned to the specific class of individuals that my co-counsel will address under the equal protection analysis in greater detail. Ultimately, the causality prong here is met because, contrary to the arguments of the state, prior to the implementation of the act, my client possessed sufficient identification to be able to cast a ballot, even given the exact same factual circumstances. However, with the implementation of the act, with the factual circumstances my client found herself in, she was unable to vote, and thus causality is directly traceable back to the act itself.
Well, I believe one of the arguments here is that your client could have voted before the name change. So does that make a difference in this case?
That's correct, Your Honor, and no, it does not. In fact, I'd point the Court's attention to two specific cases that suggest otherwise. In Dunn v. Bloomstein, as cited in footnote 24 of Justice Souter's dissent to Crawford v. Marion County Election Board, as well as Harper v. Virginia Board of Elections, as cited by the 11th Circuit in Common Cause Georgia v. Phillips, this Court made clear that an individual's ability or willingness to overcome a challenge barrier does not insulate that barrier from constitutional challenge. As such, it's clear that my client has standing to bring this suit today. Turning to the merits, we see that the right to vote clearly is a fundamental right. This Court recognized such in Illinois Board of Elections versus Socialist Workers' Party, which is cited by the Court in Burdick v. Takushi. And that right does stem from both the First and 14th Amendments. As the Court...
What is expressive? I mean, I understand that voting is important, but what is expressive about the act of voting?
Well, Your Honor, it's ultimately the fact that the right to vote is the ability of the people to have their voice in the say of who should represent them.
Oh, I agree with that, but let's take this hypothetical. You'd agree with me that if I were to go out on a street corner and say, either I think Donald Trump is the best thing in the world or I think Donald Trump is an existential threat to democracy, that's going to be protected by the First Amendment, right?
Yes, certainly, Your Honor.
Well, but what if I did it in my shower, where I'm by myself, just to be clear?
Thank you for the clarification, Your Honor.
That's really not what the First Amendment is all about, because I'm expressing it to me. And isn't voting like that because you do it in secret?
No, Your Honor. I'd submit that the distinguishing characteristic there is that hopefully there's nothing in your shower that would provide what your statements are to the outside world, which is very distinct from voting itself, wherein the results of an election are clearly communicated to the outside world. Politicians and others seek to analyze those results and see what viewpoints the people of America are expressing.
Well, but that's a collective viewpoint, isn't it? Right? Doesn't the First Amendment protect an individual right? So, for example, you can't sit here and tell me that you know who I voted for, even though Donald Trump won the election, right?
That's correct, Your Honor. I couldn't tell Your Honor precisely who Your Honor voted for. However, the First Amendment protects both speech at the individual level and at the collective level. And ultimately, this Court has recognized that the right to vote does stem from the First Amendment. And in particular, I'd point the Court's attention to the incorporation doctrine, in that the right to vote is incorporated upon the states by the Due Process Clause of the 14th Amendment. But in order...
Is your argument basically then that we have to give this statute strict scrutiny, intermediate scrutiny, rational basis scrutiny?
Well, Your Honor, while we have argued in our briefs that there is a severe burden that's imposed, and thus under Burdick v. Takushi, strict scrutiny should attach, we're willing to proceed for the purposes of oral argument today on rational basis review, because we'd like to focus on demonstrating to the Court that the Act fails even the basic test of rationality, because it does not advance any legitimate state interest. Now, we can see that the state does have a legitimate, indeed a compelling interest at play. Purcell v. Gonzalez, as cited in Crawford, makes it clear that the state has a compelling interest in preventing voter fraud. But the problem is that the Act, at best, does not advance the state's interest, and at worst, could actually actively undermine the state's...
Well, but if we're in rational basis, isn't it the case that in rational basis review, the legislature can experiment one step at a time, and so even if you're right, it might end up hurting the state's interest? Rational basis gives the legislature the ability to make those calls.
Not exactly, Your Honor. The legislature does have the ability to choose whichever means it believes is the wisest to advance its interests. However, it must actually advance the interests being promoted by the state. The interest, again, that the state has at play is the interest in preventing voter fraud. But the key problem here is that the Act never requires that the identification that an individual voter presents be compared against the list of eligible voters to determine whether or not that prospective voter is a qualified voter who is eligible to cast a ballot. But even giving the state the benefit of the doubt here, and supposing that somewhere in some statute that's not in our record today, that there is such a requirement, that actually makes the problem worse. As in my client's circumstances, she would have been required to present a name that did not match her name on the voter registration rolls. And that is actively undermining the state's interest in preventing voter fraud. Creating a system within which individuals are presenting identification that does not match their name on the voter registration rolls is actively undermining the state's interest in preventing voter fraud, and thus it fails the basic test of rationality. And in fact, I'd submit to the Court that this is the definition of irrationality. On that...
Is there evidence in our record to indicate the extent of voter fraud in this city, state?
Your Honor, I see my time has expired. May I answer?
Yes.
Thank you, Your Honor. Your Honor, there is evidence in the record. Between the 1990 and 2000 census cycles, there were exactly 8 convictions for voter fraud in the state, and between 2000 and 2010, there were exactly 16. Thank you, Your Honor.
May I proceed? Madam Chief Justice, and may it please the court. My name is Meridian Paulton, and I represent the petitioner Billie Jean DeNolf on her equal protection claim. We ask this court to reverse the ruling of the 14th Circuit and find that the Anti-Voter Fraud Act is unconstitutional because it creates an invidious classification. We ask for this ruling for 2 reasons. First, pursuant to Harper v. Virginia State Board of Elections, as cited in...
What exactly is this invidious discrimination? Can you define that for us? In terms of what specific facts of this case you're referring to?
Yes, Your Honor. We ask this court to find that the invidious classification is on individuals with a recent name change, and we recognize that that's not a constitutionally protected class. So we only ask for rational basis review. However, it does have a discriminatory impact on individuals with a recent name change or who are in need of a name change close to the election. Those individuals are affected by multiple aspects of the Act. First, we see the issue of the provisional ballot. The provisional balloting period is only 3 days. Now, if the provisional balloting period was the same as that in Crawford, in which this court upheld a similar statute where there was a 10-day provisional balloting period, my client would have been able to vote.
Shouldn't the legislature be the one making that decision between, exactly how many days is the right amount? Should this court be the legislature in determining whether 3 or 10 is a reasonable or rational period?
Your Honor, we don't ask this court to legislate from the bench. That's certainly not what this court has traditionally done. However, we do ask this court to recognize that this does have an invidious impact on these individuals with recent name changes.
Yeah, but isn't it the case, though, that anytime, almost any time, a legislative body acts, it draws distinctions. So, if you get EBT, food stamps, the distinction is between somebody who makes a certain amount of money and somebody who makes 1 cent more than that line, right? And so the legislature drew a line here, it seems to me. And so if we're in rational basis review, it's difficult to say this is irrational. It might not be what I'd vote for if I were in the legislature.
Your Honor, regarding specifically the food stamp analogy, for example, we actually do have a couple of cases within our record that refer to government benefits and how the legislature can, in fact, make whatever line it wishes regarding that. However, this is not a government benefit which we're talking about. This is the right to vote. And while we don't contend that there's a right to vote on any given day, this is not the right to vote on August 24th or the right to vote on Christmas. This is the right to vote on Election Day, the date that the state has chosen for individuals to vote.
As a part of your equal protection argument, the fact that if you don't vote in person and you send in an absentee ballot, there's no problem. How do you prove, if the basic purpose of the statute is to prevent voter fraud, how does allowing people who vote by mail and don't have to show any ID going to advance any purpose, that purpose of preventing fraud? Certainly anybody who votes by mail would in fact not be the person.
To be sure, Your Honor, part of the problem with this act is that it actually doesn't advance the government's interest. In fact, as my co-counsel already noted, there is a requirement typically in voter ID laws that an individual's name on their ID matches their name on the voter registration roll. That was the requirement in the state of Indiana, that in the Crawford statute, that this court did uphold. And that fulfills the government's interest of preventing voter fraud because we make sure that the name on the ID matches the name on the voter registration roll.
Can you give us a case that's in the record that supports where it was unconstitutional based on the rational test that you're talking about?
Your Honor, the only
What is
case...
the strongest case you have for that position?
Your Honor, the only case regarding voter ID law specifically that we have from this court is Crawford. But there's some distinguishing factors between the Indiana statute and the statute before us today. First is the provisional balloting period that I already mentioned, where my client would have been able to vote. And then we also have this additional issue of the match. And that's key because currently what my client is in a position of is she has to choose between two options. Either she cannot vote on Election Day, or if she wishes to vote on Election Day, she essentially has to definitionally commit voter fraud. That's what the state would ask her to do. Because on the voter registration rolls, her name says Billie Jean King. Now, under the Crawford statute, she would show a Billie Jean King ID. She would be allowed to vote. But the state of Olympus asks Billie Jean DeNolf to present an ID saying Billie Jean DeNolf when the voter registration rolls still say Billie Jean King. That's what voter fraud is, Your Honors.
So can I just want to pin you down about precisely what it is that makes this irrational under the, so I'm assuming you're conceding the first prong of rationality review, that there is a legitimate state interest.
Certainly, Your Honor.
So that it's all about whether what the state has done is rationally related to serving that interest, right?
Yes, Your Honor.
So what is it precisely in the statute that makes it irrational for the legislature to enact?
That, Your Honor, when we look at a case like what happened with my client, she is forced to definitionally commit voter fraud in a statute that is intended to prevent voter fraud.
Well, no, that's not quite right? So it's just that she can't cast the ballot because the name doesn't match, right? So you see what I'm getting at, right?
Yes, Your Honor.
You're saying, hey, in order to comply with the statute, I'd have to lie, essentially, right? Say my name is Billie Jean King, even though it's Billie Jean DeNolf or the reverse, right?
Not quite, Your Honor. The problem is that her name is now Billie Jean DeNolf. And under most statutes, though, since she doesn't have an updated ID, she would be allowed to present Billie Jean King because that's the current ID that she possesses. In fact, federal law mandates, as you can see in Crawford, that there is a matchup that is available between your ID, your driver's license, and the voter registration roll. So those would update concurrently. So while they're in this awkward phase, she would be allowed to use the name Billie Jean King to vote. And that makes sense.
Right, but so my question just is, I agree with you that the Olympus law, no offense to the respondent on this point, is stupid, right? It doesn't make a lot of sense in the sense that, why have somebody do that? But it might not be irrational in the sense that it will capture fraud even though it is over-inclusive, but that isn't enough, is it?
Your Honor, it's not rationally related, not only because it doesn't allow those individuals, or because it forces individuals like my client to essentially definitionally commit voter fraud, but also because of this invidious classification that prevents people from voting altogether. So we have these 34% of women that don't have the current name listed on their ID. We've seen a 12.5% decrease in female voter participation as a result of that. And that's only traceable, as my co-counsel already noted, back to this act.
Yes, but what relevance does the fact that there happen to be females be, right? Because if we're talking about females, then that suggests that we need to consider whether we should apply intermediate scrutiny.
Your Honor, I'm nearly out of time. May I briefly answer the question?
Yes.
That is because, Your Honor, women are more likely to change their name than men. So we can see from that example of women and from the 12.5% decrease in the recent election that this has had this negative effect, not to mention the lack of a rational relationship. We ask for reversal. Thank you.
Madam Chief Justice, Your Honors, and may it please the Court. My name is Kevin Kim, and I, along with my co-counsel, Ms. Colleen Slane, will be speaking on behalf of the respondents, the State of Olympus, in the case of Barr. I will be addressing the standing issue and the equal protection issue, and my co-counsel will be addressing the voting rights issue and the free speech issue. Your Honor, this case is about an attempt to get this Court to overstep its history of judicial restraint and violate the very Constitution it was established to protect. Hence, I will make 2 points. 1, that Judge DeNolf does not have standing to bring this issue, and 2, that the Voter ID Act does not violate the Equal Protection Clause.
And it seems to me that she was directly affected. She went to She wanted to vote on voting day. She did not. It takes the state, it seems, an inordinate amount of time to change one's name. And so what other option does she have? Why isn't she directly affected by this statute?
Well, Your Honor, your question goes to the first prong of the Lujan test, which requires an injury in fact that is concrete and particular, not or actual or imminent, and not hypothetical. Well, Judge Janolf's actual injury is a hypothetical injury. Now,
Did she get to vote on election day?
no, Your Honor, she did not.
So why isn't that a concrete injury?
Well, Your Honor, although she was not able to vote on Election Day, she had the information and the means to vote by an early ballot. Hence, her injury is not an inability to vote. Her injury is submitting an early ballot. However,
Why should she be required to do early voting as opposed to voting on election day? There are lots of people in this country who love going to the polls on the actual election day, and she was denied that opportunity.
yes, Your Honor, if Judge Janolf wanted to vote on Election Day, then she should have properly changed her name and gotten the proper credentials to do so. However,
How could she have done so when she got married only a few days before the election? She certainly could not change her name before she had in fact changed her name, could she?
no, Your Honor, she could not have. But if she waited even one day before to legally change her name, then she would have had still a valid ID that reflected her maiden name and her legal name, and she would have been able to vote on Election Day.
So couldn't we simplify the injury prong here by just saying that somebody who didn't have this issue had three means by which to cast their ballot, right?
Yes, Your Honor.
They had in-person, by mail, or early voting.
Yes, Your
right?
Honor.
And this person had only two, or maybe only one, depending upon whether she had to have a photocopy of whatever it was. Doesn't that answer the question about whether there's an injury because they have fewer means to exercise the franchise?
No, Your Honor, because petitioner or even plaintiffs are not guaranteed a right to vote in any which manner that they wish to. If they wish to vote after Election Day, then it would still be an illegitimate vote. However, Judge Janolf, the only reason why she did not want to submit an absentee ballot was because she wanted to wait until Election Day to gather pertinent information about the candidates. However, Your Honor, the 2 weeks preceding the election, there is no guarantee to what information Judge Janolf will receive. Hence, that information is hypothetical. In Lujan
Does that really make a difference?
Yes, Your Honor, it does, because Lujan, the first prong of Lujan requires that the injury be concrete. Now, the information Judge Janolf seeks is not concrete. Although in FEC versus Akins it specifically noted the importance of information for voters, the information sought by voters in FEC versus Akins is fundamentally different from the information sought by Judge Janolf. In that in FEC versus Akins, that information existed concretely in the form of documents and spreadsheets that showed which candidates were receiving how much money from a political action committee. The information Judge Janolf seeks doesn't exist in that tangible form. It only exists in the realm of hypotheticals. Hence, because her injury is hypothetical, we cannot say that the Voter ID Act caused such an intangible injury.
Did you say you were also going to argue the equal protection? I think maybe we should get to that particular issue.
Yes, Your Honor. In the realm of equal protection, if we were to look at the merits of this case, to prove that the Voter ID Act violated the Equal Protection Clause, we need to show both a disproportionate impact as well as a discriminatory intent. As this court noted in Arlington Heights versus the Metro Housing Development Corporation, that official action will not be held unconstitutional solely because of a disproportionate impact.
So, what was interesting is it seems that the petitioner has conceded that only the lowest level of constitutional scrutiny applies. And so it seems like the line they're drawing are between anybody in the world that has an ID with their name and anybody in the world that has an ID that doesn't have the same name as their name. So there doesn't really need to be, on their theory of the case, apparently, a disproportionate impact, right?
Yes, Your Honor. On the petitioner's side of the case, they submitted to rational basis review. However, they contended that the Voter ID Act is irrational. However, quoting Crawford versus Marion County Election Board, this court stated in 2008 that there is no question about the legitimacy or importance of the state's interest in counting the votes of eligible voters. When Judge Denolf decided to change her name 2 days before the election, she became an illegible voter. And as despite what petitioner states, the Voter ID Act doesn't ask Judge Denolf to commit voter fraud. They ask Judge Denolf to simply get a valid photo identification. Hence, Your Honor, because the Voter ID Act is rational and it follows the state interest, then we can find that the Voter ID Act fulfills the rational basis review. But going back...
Well, you know, you can say that it's rational, but why do you contend that it is in fact rational? It seems to me that there are lots of holes in this and lots of exceptions to it, and you know, so why would you contend that it's rational?
Your Honor, we see that the Voter ID Act is rational by looking into the historical significance of voter fraud in the state of Olympus, which falls into one of the factors outlined by Arlington Heights versus the Metro Housing Development Corporation.
And if I understand the record, the voter fraud is almost de minimis in the state of Olympus. So why go through all of this, put all the citizens through this for such a de minimis return?
Well, Your Honor, here's the specific sequence of events leading up to the passage of the Voter ID Act. By 2010, when the Voter ID Act was passed, the state of Olympus saw a 100% increase in the count of voter fraud. Now, Chief Justice has noted that it's still only 16 counts of voter fraud. However, if the state is not able to step in at 16 counts of voter fraud, then how long should we wait until we can defend the very foundation of our democracy? Is it 8 to 16, or is it 16 to 32, or possibly 64? Well, this court answered that question in Crawford versus Marion County Election Board, in stating that we don't even need one count of voter fraud.
Why the exception then for not if you're voting not in person? I mean, isn't there that exception to me seems to undermine your argument, because those are certainly people who could commit voter fraud.
Yes, Your Honor. While there are people who can commit voter fraud, perhaps by absentee ballot, the state of Olympus still wants to accommodate their vote, because a vote doesn't really, or an election doesn't really matter if the entire population isn't included in it. So by allowing for absentee ballots, by allowing for provisional ballots, we allow for members of the public who are unable to vote on election day, such as military members, who need to submit an absentee ballot.
And it seems to me military people are probably the very ones who do in fact have IDs.
Yes, Your Honor, they are legitimate IDs at that. However, Your Honor, even more to show how rational the Voter ID Act is, in response to that 100% increase in 2010, the footnote 1 of the record shows that 75% of Americans believe that voter fraud is an issue. Now the legislation, exercising their constitutional duty to their constituents, listened to that voice and enacted the Voter ID Act. As with, if we don't even verify the identity of those entering the ballot booth, how can we ensure the very veracity of our election process? Nevertheless, Your Honor, to prove that a law violates the Equal Protection Clause of the 14th Amendment, we must prove a disproportionate impact as well as a discriminatory intent. However, there is no intent on behalf of the legislation to discriminate against women or any other group at that. In essence, Your Honor, we see that the Voter ID Act sought to address our constituents' concern as well as limit the counts of voter fraud.
Well, the legislature probably had information that this would impact women more than men, because men don't normally, as a general rule, change their names when they get married, do they?
Your Honor, I see my time is about to expire. May I address your question? Yes, Your Honor. And although they knew of the impact, it doesn't necessarily mean that they intended to do so, as we saw in Arlington Heights, where the legislation knew of the racially disproportionate impact that a denial of a zoning ordinance would have, but because of their neutral justifications, the court found them to be valid. And because the Voter ID Act has neutral justifications in protecting our democracy, we ask this court to affirm the decision of the 14th Circuit. Thank you.
Good evening, Madam Chief Justice, Your Honors, and may it please the Court. My name is Colleen Slane, and today I'll be speaking on behalf of the free speech and voting rights issues for the respondent, the state of Olympus, in the case at bar. Your Honors, simply put, the case before you today is about the Article 1, Section 4 constitutionally designated right of the states to reasonably regulate the times, places, and manner of their own elections. Your Honor, we ask you to affirm the decision of the 14th Circuit for
Their point on this, whether in terms of expressive conduct and whether the First Amendment applies, is that voting is expressive conduct. I think it's Johnson versus the United States case. Can you explain why you think that voting isn't as expressive as any citizen's right or any other expressive conduct that a citizen takes, like burning the flag? Why can't voting in and of itself be expressive conduct?
Certainly, Your Honor. In Texas versus Johnson, as cited in Voting for America versus Steen, this court outlined two factors in order to define whether conduct is expressive. These two factors include whether the conduct intends to convey a message, and second, whether that message can be reasonably understood by the audience. And while the petitioner meets the first prong, that casting a ballot and voting certainly does intend to convey a message, they do not meet the second prong of the Texas versus Johnson test, in that the audience cannot understand that. When a person casts a ballot, they're pressing a button or perhaps pulling a lever, and no one can understand that action as who they voted for or what political message that they are trying to get across. Additionally, this court has never held voting to be considered under the First Amendment expressive
But
conduct.
does it really matter whether we know what they did or how they voted? Isn't it the sheer fact that they are exercising their right to do so, no matter what who or what they vote for?
Yes, Your Honor, and Ms. Billie Jean DeNolf certainly could have gone in and cast a ballot. The difference is the ballot simply would not have counted. So if that's the only thing that...
What's the point if your ballot isn't going to count?
Well, Your Honor, if you wanted to convey to the people around you who you were supporting, or you wanted to voice political support for the system in general, one could definitely step into the ballot box and cast a ballot. But if you do not present the valid form of identification required by the Voter Identification and Anti-Voter Fraud Act, your ballot cannot be counted.
But doesn't that meet both prongs? If it's the act of voting, you've admitted that it's expressive conduct, right? You're just saying that it's, in essence, it's not in a public place or it's not heard. But the idea of not being allowed into the voting place, where you cast your ballot, is in fact expressive conduct seen by people. And if you're not there, that's seen as well. Why doesn't that meet both of those prongs under Texas?
Your Honor, even if you do consider voting to be speech under the expressive conduct test articulated by Texas versus Johnson, you must go through a non-public forum analysis in order to analyze whether a regulation infringes on that expressive conduct right. In a non-public forum analysis, as articulated by Voting for America versus Steen, this court...
Let me stop it just 1 second, because I want to make sure I follow you. What is the forum that you're talking about there?
Your Honor, Voting for America versus Steen said that the polling place is considered a non-public forum, and therefore we must go through this non-public forum analysis. However, the level of scrutiny applied to a non-public forum requires only that a statute be viewpoint neutral and reasonable in light of its purpose. In other words, it's not a high threshold to meet. So the Voter Identification and Anti-Voter Fraud Act easily passes the threshold of being viewpoint neutral and reasonable in light of its purpose. It's simply trying to prevent fraudulent votes and lower the statistic that 75% of Americans believe that voter fraud is an issue. The simple public perception that 75% of Americans have is an issue in and of itself, as one of the interests articulated by the state of Olympus is to increase voter confidence in the polls.
So let me ask, you started out before, I think, Mrs. Manson asked you a question about mentioning the state's ability to regulate the time, place, and manner of elections. How does that power preserved to the states in the main body of the Constitution interact with the First Amendment if we assume that the First Amendment protects the right to vote as expressive conduct? In other words, how do we reconcile those two pieces?
Your Honor, if I understand your question correctly, you're asking whether or not the fact that the First Amendment protects the right to vote rebuts the fact that it does not fall under expressive conduct?
Well, yeah, so you probably asked it better than I did, but if the First Amendment protects a right, then we usually would use some form of heightened scrutiny, depending on what type of speech it is, etc. But on the other hand, if the main body of the Constitution gives the states the ability to regulate that right, we would normally use a lower level of scrutiny to judge what the state does. And I'm wondering, how do we fit those together?
Well, Your Honor, in 1992, this court articulated a test in Burdick versus Takushi, which is really a test from the Anderson versus Celebrezzi case that this court decided in 1983. And it provided a sliding scale test to determine how, whether or not a regulation may infringe on the right to vote. What they determined is that in order for a regulation to infringe on the right to vote, the importance of a state interest must outweigh the character and magnitude of the injury experienced by the petitioner. And that's exactly what we see here. Your Honor, in Burdick versus Takushi, this court found it to be a relatively low burden on voters. And while Burdick versus Takushi is distinguishable from the case at Barr, Bullock versus Carter, as cited in that case, stated that it minimizes the extent to which ballot access and ballot content cases are distinguishable.
So how many people would have to be excluded from voting before it reached some level? You said it's de minimis, this idea that only this particular petitioner and other people don't get to vote. I mean, we had the poll tax, and that was ruled unconstitutional and prevented people from voting, so why wouldn't that apply in this case?
Your Honor, poll taxes were contended by both parties to not be in contention today. However, there's no certain level of number of people that would have to be prevented from voting to make this statute unconstitutional. Rather, the sliding scale test still applies. In other words, although some people are prevented from voting, so are all fraudulent voters. And as Dunn versus Bloomstein, as cited in Crawford versus Marion County Election Board stated, the right to vote is not absolute. However, there is a constitutional right of the states to reasonably regulate the times, places, and manner of their elections.
But shouldn't that right to regulate voting, I mean, you have to look at it in the context of whether or not the state is actually erecting barriers to people having an opportunity to vote, unnecessary barriers to one's exercise of that right.
Your Honor, the respondent would contend that the barriers that it is erecting for people to vote are certainly not insurmountable, and therefore the burden is not severe. It's simply a slight burden, as articulated in Burdick versus Takushi and the more recent case, Crawford versus Marion County Election Board.
It's a slight burden, and for example, in this case, she didn't get married until several days before. The state will not process name changes for 10 to 14 days, and so what other option does she have?
Your Honor, the petitioner should have planned ahead a little bit better because the state cannot control its own...
She should have changed the date of her wedding so that there would be that 10 to 14 day period to get her name changed before the election.
Not necessarily, Your Honor, but the state of Olympus should not have to change the way it regulates elections simply for one person to be able to get married on a day of their choosing. Now, if Ms. Billie Jean Denolf chose to get married in the middle of the election, it would be the same as if a Muslim individual decided to make the Hajj to Mecca in the middle of the election. While they did not necessarily, their right to vote was forfeited in them taking that trip at that time. It was not the state saying you cannot vote during this time.
But that's certainly a completely different situation because the state hasn't stepped in and said you can't, you don't have the proper ID. The person has chosen to go to Mecca at the time of the election. So that, I think that analogy doesn't really hold water here.
Certainly, Your Honor. Then maybe we should compare it to other voter identification laws. And when we compare it to the 2008 law Crawford versus Marion County Election Board, while the petitioner asserted that her client would be able to vote under that provision, even with the 10-day provisional ballot period that case applied in their law, there's still a large chance that their client would not have been able to vote because it's a 10 to 14-day turnaround for the state.
So should it be a 14-day period?
Perhaps, Your Honor. But even in Common Clause Georgia versus Billups, an 11th Circuit case, they upheld a voter identification law that only had a 48-hour provisional time period. Your Honor, perhaps Kahn versus Shevin, as cited in Michael M. versus Superior Court, said it best. The issue is not whether this statute could have been drafted more wisely, but whether the lines as chosen by the legislature are within constitutional boundaries. And certainly they are. For these reasons, we ask you to affirm the decision of the 14th Circuit. Thank you.
You have a rebuttal?
Yes, Your Honor. May I proceed? May it please the court. In an attempt to prevent voter fraud, the state has presented my client with a Hobson's choice. Either she can forego her constitutionally protected right to vote, or she can commit voter fraud. All this, in the name of a statute the state alleges is designed to prevent voter fraud. Your Honors, this is the definition of irrationality, and this statute deserves to be relegated to the dust heap of unconstitutional attempts to disenfranchise lawful voters.
So you're actually saying that your client could have voted, she could have presented herself at the polling place with an ID that showed her name as Billie Jean King, correct? Billie, is that her name, Billie King?
Her maiden name was King,
Okay.
Your Honor.
That's the name that was on the voter roll.
Correct.
So if she had shown that ID, nothing more could have been done.
But under the plain language of the statute, Your Honor, she would have been committing a second-degree felony, a felony that would have been fatal to her career as a judge in the state of Olympus. Ultimately, that choice is sufficient to confer a standing upon my client. And while the state has adopted the same victim-blaming mentality that this court has rejected repeatedly, most notably in Kirchberg, it's clear that my client, even though she could have voted during the early voting period, still has standing to challenge the act. Indeed, this court rejected an argument quite similar to that raised by the state today in Kirchberg, in which this court rejected the idea that because the plaintiff there could have taken steps to avoid or mitigate the harm that befell her, that she still had standing to challenge the act in question there. Likewise, my client has standing to challenge this act today. But even when evaluating this act in the light most favorable to the state and evaluating it under rational basis review, the fact of the matter still remains that even though the state has a legitimate, indeed a compelling interest in preventing voter fraud, this act is not rationally related to that interest. And that's because the state doesn't do anything to ensure that it's actually advancing its interest. There's nothing in the act itself that ever requires any comparison be made between the voter identification presented at the polls and the list of eligible voters. Thus, there's no way the Voter Identification Act could actually combat impersonation voter fraud. And indeed, even if there was such a requirement, somewhere in some other statute, not in the record before this court today, that actually makes things worse for the state. Because in that case, my client would have been required to present an identification that affirmatively did not match her name on the voter registration rolls. And Your Honors, that's something that is factually indistinguishable from voter fraud, and an act that encourages conduct of that sort does not and cannot advance the state's interest in preventing voter fraud. Instead, it simply strips my client of her constitutionally protected right to vote, and it's on that basis that we urge reversal. Thank you very much.